Hello, everyone. I'm very delightful to start this webinar on ESOP in startups and growth companies, which will overview the Baltic scene as well as international trends. I'm Aquila Boseta, a partner at Cobalt Lithuania office. And a short intro to the whole webinar and the speakers is that we saw in Cobalt offices in all the jurisdictions that the ESOP topic is becoming again more and more popular, and since our startups that emerged in the Baltic countries like 15 or 10 years ago, they grown up more mature, and their questions on the ESOP side also became more and more difficult. And when like several years ago we spoke only how to properly grant ESOPs, now we are speaking and dwelling into questions: what happens when the ESOPs are exercised, what happens when there are leaver events, how you treat the ESOP holders as shareholders in your cap tables, etc. So the questions became more difficult, and we saw that this is a good time to speak, especially when we have spoken to our good friendly firm Cooley from UK, which we have a representative in this webinar, because we all have in Cobalt offices the feeling and the practice of the Baltic states. But it is always very good to compare and to gain knowledge of how the things, and especially ESOP, are functioning in UK and more generally in Europe. So today I have a crowd of speakers together with myself. So let me briefly introduce them. I have Crystal Raidla-Talur from Cobalt Estonia. And Tom Schulman is from Cobalt Latvia. They are both experts on the ESOP side on VC and corporate matters. We also have a tax experts on ESOP side from each the Baltic jurisdiction. That is Rokas Dulgela from Lithuanian office, Sandija Novicka from Latvian office, and Tonu Kolts from Cobalt Estonia. And last but not the least, we have a guest speaker, Paula Holland from Cooley, UK, which is knowledgeable both on VC, corporate, and tax side, and she will be the one who would shield the wheel of what is the practice in UK and Europe, much more mature in terms of ESOPs. So, not to waste everyone's time, let me handle a word to Crystal Raidla-Talur, who will make intro about VC corporate terms on the ESOP side, followed by the short intro on taxation side, and then we will move to the discussion, which I believe will be the most interesting and fruitful. So, Crystal, the word is yours.
Thanks, Aquila. Hello from me as well. As Aquila already mentioned, I'm from Cobalt Estonia, and I'm heading our venture capital practice in the firm. And the truth is that in one way or another, we come across options in almost all of our assignments. So we will have a discussion among corporate and tax lawyers from the Baltics and Paula from UK later during the webinar. But in order to have a good structure for the discussion and also make it easier for the audience to follow what we're talking about, I will now take around 15 minutes to walk you through some basic features of options and also market practice in the Baltic region. And then Paula can later chip in on international practices during our discussion part of the webinar. So we have a few slides, and maybe let's then kick off with the first one. Let's start with the definition, as things are often done. So what is an option? It's a right of the holder to acquire shares in the future at the price agreed at the time of grant. The option holder may be an employee, service provider, an advisor. These are the usual recipients of options. In the future, usually means a few years. We will come back to this in the context of vesting and exercise a little bit later. And we will also come back to the strike price. This is something our tax team will talk about once I've finished. Setting up an option pool is a matter agreed between the shareholders. It doesn't involve issuing the respective shares. It basically only means that the pool size is agreed and the respective row is inserted in the cap table, in the Excel file that startup companies tend to have. And by doing that, reflecting the option pool in the cap table and agreeing the pool size in the shareholders agreement, all the shareholders acknowledge and accept that once the employees exercise the options, they are entitled to get the shares, and this issue of new shares at the time then causes dilution for the other shareholders. In the Baltics, the size of the option pool tends to be around 10%. That is of the fully diluted share capital of the company. And while in some jurisdictions, I believe especially in the US, the percentage tends to grow as the companies go through their financing rounds and mature, we see that in our region, the pool often remains at 10% throughout the rounds. It doesn't mean that the pool remains to be tied to the same number of shares. The pool is usually still topped up in each financing round to make sure that it remains at 10%, but the tendency really is that it doesn't get much higher than that. Now, the fact that the option pool is created doesn't mean that the option holders are known at the time. Someone still has to decide on the allocations. It is usually so that the shareholders agree the size of the pool and also approve the option plan or program outlining the main terms. However, it may also be agreed that approving the plan or program is a board level matter. And then we get to awards or grants to specific employees. Who gets the options and how many? This is usually a decision made by the executive management level, either the management board or the CEO. As you can see, we have a few slashes on this slide. It is because the practice really varies from company to company and from country to country. And among other things, the practice is also affected by company structure and governance. And this may be different in some jurisdictions, also in the Baltics. I know that it is different, for example, in Estonia and Lithuania. Then also perhaps worth to mention one technical issue related to the grants. Lower nominal value of shares means that you can have more precise grants and you can award more shares to an employee. A few years ago, in Estonia, the lowest possible nominal value of a share used to be €1, and nowadays it's €1. So if such nominal value is reflected in the articles, then the company can arrange the awards accordingly, means more precisely. As regards the documentation, it should be noted that options may be granted based on option plan or program or based on separate option agreements. Either way, there should be a written piece of evidence to make sure the company and the option holder both agree to the terms. In Estonia, it tends to be the case that early stage companies often start off with separate option agreements. These are usually concluded with all relevant employees on the Startup Estonia model option agreement. And at some point, the company decides to create its own option plan or program document. And that would be then also accompanied by a one-pager that each of the employees would sign. But these are more legal technicalities, I would say, not so much affecting the substance of the options. In addition to legal documentation, it's important to make sure that there is a solid solution for keeping track. And I mean keeping track of our allocated and unallocated pool, and also all the options granted. A very basic solution is an Excel file that many companies use, but just to keep in mind that there are also several platforms offering relevant services so that companies can manage their cap table and including options more conveniently. I'm sure many of you know that there is Carta, for example, that is very popular in the US, but also, you know, there are platforms of Estonian origin, SaltoX, for example, that is designed for European companies. So also really, really helpful in relation with options. Now, let's get deeper into the terms and talk a little bit about vesting, exercise, and acceleration. First of all, vesting. Vesting means earning the right to acquire shares. Usually vesting occurs over a period of 4 years, and this is split into two parts. There is 1 year cliff, which means that the first portion of the shares vests on the first anniversary of the grant date. So if an employee leaves before the first anniversary, for example, after having worked only for half a year, nothing has vested. And then after the cliff, there is a 3-year period during which the vesting occurs at small intervals. So it's usually monthly. And then, you know, with regard to the relevant portion of shares. So if an employee leaves after having for 1.5 years, for example, then options corresponding to 1 year and 6 months would be considered vested. There are also alternatives to these traditional vesting schedules, and some of these are not very often used, but I'll mention these anyway. So, you know, the more often used alternatives would be to have a shorter vesting period, or for example, or quarterly vesting and things like that. But in addition to these, sometimes, although in my view, very rarely, a backloaded schedule has been used. The example on the slide shows that there is greater motivation to stay longer, since major portion of the vesting only occurs towards the end of the vesting period. So this is something that the companies may consider for retaining talent. But a bit more often, we have also seen attempts to have KPI-based vesting. This means that in addition to the time-based vesting, there are also some performance metrics in place. However, I would say that since the ability of an individual employee to influence financial results, which are usually the basis for the metrics, is quite limited, and it is really difficult to come up with good metrics for most positions, really. And that's why I would say that KPI-based vesting still is also quite rare. Moving to exercise. Exercise means that the option holder can convert the options into shares and become an actual shareholder. In this respect, options may be designed in various ways. Usually, the employees would have the right to exercise and become shareholders after a certain number of years has passed from the date of grant. In Estonia, for example, it is quite common that it's 3 years, and this is related to the tax exemption that our colleagues will talk about a bit later. But the exercise may also be tied to a longer period. For example, the entire vesting period of 4 years can also be used. Earlier exercise is usually possible upon exit or liquidation. And alternatively, employees may only be allowed to exercise upon exit or liquidation. And they may only receive proceeds from the exit or liquidation event and never become actual shareholders. So there are many, many ways to design this. Acceleration is something that allows to speed up the vesting schedule. The common approach in our region is that there is no acceleration. If there is any acceleration, it tends to apply to top-level executives only. It tends to be related to an exit event and operate as double trigger acceleration. This means that in addition to an exit, acceleration assumes that the executive becomes a good leaver, in simple terms, is fired. And this happens within 12 months from exit. And then acceleration may involve automatic vesting of all or some portion of the unvested shares. Now, finally, let me touch upon levers. Lever provisions are designed to deal with the situation where the option holder leaves the company. Typically, levers are either bad levers or good levers. Bad lever means termination for cause, basically behaving in such a way that the employee is asked to leave. However, at least in our region, bad lever very often also includes an employee who leaves on his own initiative without really any specific reason, or at least without any reason related to the current employer. It may be due to finding a more interesting job or a more lucrative job, for example. And good leaver is typically defined as any leaver who is not a bad leaver. So it's a simple definition there. However, there's quite a bit of controversy around treating someone who leaves on his or her own initiative and without committing any breach as bad leaver. Employees often find it difficult to accept the term itself. Bad leaver sounds really bad. And also, of course, relevant consequences. So for this reason, it is not rare. And actually, in my view, it becomes more and more common that companies make their option program more attractive by saying that the voluntary leaver is a good leaver. Alternatively, there is also another solution that has been used, especially during recent years, and that is introducing a separate voluntary leaver category. So why do we have all this discussion about labeling the levers? The reason is that different lever events have different consequences. So bad lever usually means that the options held by the employee terminate with respect to both vested and unvested shares. And good lever, on the other hand, gets to keep the vested shares. And the options terminate only with respect to unvested shares. and voluntary leaver is somewhere in between. And the last point of this intro, companies may try to avoid having former employees on the cap table by having the right to repurchase the vested options. This is also something that we see in many, many option programs. So this was a very quick tour around the world of options, hopefully a bit helpful for the discussion that we will have later. I will now hand over to my colleague Tõnu, who will go through some tax issues, and then we can move on with the discussion part. Tõnu, the floor is yours.
Yes, thank you, Crystal. So let's now move forward with an overview of tax issues. As you know, there are two certainties in life, and one of these are taxes. I'm quite sure that some of the topics that we will cover are familiar to many of you, but if you have any specific questions, then feel free to post them and we will try to address them later. For introduction, I would like to highlight that Estonia, Latvia, and Lithuania all have very competitive tax rules for share options. Each country has established specific tax exemption rules that are generally easy to understand and implement. It's also important to understand that the taxation depends on where the employee is located, not where the issuer company or the employer is based. But yeah, now let's take a look at the first slide.
Yes.
So the first thing to know is that there are two main triggering events for taxation. The first one is the exercise of options, and the second one is the sale of shares. In some jurisdictions, the grant may also trigger taxation if the exercise price is lower than the fair value of the shares underlying the option at grant. However, in Estonia, Latvia, and Lithuania, there is no taxation upon grant. So what is the taxable value? Unless the exercise of option is subject to tax exemption rules, which conditions we will discuss shortly, the taxable value upon exercise of option is the difference between the fair market value of the shares underlying the option and the exercise price payable by the employees, if any. So a simple example would be that if the market value of the shares is 1,000 euros and the exercise price is 100 euros, then 900 euros would be the taxable value from which applicable taxes are calculated and paid. In case of sale of shares, the taxable value is the received gain, which is taxed with personal income tax. And the gain is the difference between the sales price and the acquisition cost of the shares. I think it's necessary to understand that the acquisition cost includes, in addition to the exercise price paid by the employees, also the value which was subject to taxation upon option exercise. Next, who is liable for the payment of taxes? In case of exercise of options, generally it is always the employer. However, Lithuania has one exception. So the exception is that if the employee will be responsible for payment of taxes if the share option is granted by a foreign group company. So basically not the employer itself. However, in the event of sale of shares, it will always be the employee who will be responsible for the calculation and payment of taxes. And we can now move forward to the next slide. On this slide, you can see the general conditions for applying tax exemptions in Estonia, Latvia, and Lithuania. Please note that the exemption can be applied on the exercise of option and is not related to the sale of shares by the employees. In Estonia, there are two main conditions that need to be met. The first one is that there must be at least a 3-year period between the grant and exercise of option. And the second condition is that the underlying shares of the option must be the shares in the employer or another group company. In addition, in Estonia, the tax exemption can be applied proportionally, for example, in cases of full exit or in case of the death of the employee, and the tax exemption in this case is calculated proportionally from the moment of granting the option and when the specific event occurred. So this applies when this event occurs prior to the 3-year period. And one more condition that in Estonia needs to be taken into account is that unless the option agreement is digitally signed based on the EU rules or notarized, the employer is required to submit the agreement to the Estonian tax authority within 5 business days. However, in practice, alternatives to digital signing and notarization, such as the DocuSign platform or option management software like Carta and Legi, are also accepted. So basically, what the Estonian tax authority wants to make sure that there is a timestamp. Next, in Latvia, the conditions are as follows. First, that there is at least a 12-month holding period between the grant and exercise. The underlying shares of the option are the shares in the employer or another group company. The employee must stay with the employer. The share options must be exercised within 6 months after the employment is terminated. And the employer or the issuer company has not provided a loan to the employee to exercise the option. And the most important condition, in my opinion, is that the Latvian tax authority is duly notified on the granted share options within 2 months from the grant date. I think the last one is very important, as we have seen that companies forget the registration part, and if this is discovered prior to option exercise, it is not possible to use the tax exemption. In practice, we have used, tried to solve this, for example, in a way that we have cancelled the prior agreements and signed the new ones. But next, in Lithuania, the conditions are similar to Estonia, namely that there is at least a 3-year period between the grant and exercise of the option, and the underlying shares of the options are the shares in the employer or another group company. However, as a third condition, the tax exemption can be only used in Lithuania if the option is exercised when there is still an employment relationship. So, what are the key takeaways from this table? If the option agreement or the plan is designed for exit events, then Estonia has the most flexible rules to cope with that, because there is no requirement that option needs to be exercised while the employment relationship is still effective or 6 months after that. In other words, there is no requirement to issue shares to benefit from the tax exemption before the exit event occurs. Latvia certainly has the shortest holding period requirement, 12 months compared to 3 years applicable in Estonia and Lithuania. So it will be much quicker to make an employee reach to share options in Latvia compared to Estonia and Lithuania. Lithuania has the least rules with respect to any reporting or formalities when it comes to granting options. So to recall, in Estonia, there is formality regarding the signing of the option agreement, and in Latvia, you have to register the options with the local tax authority. Okay, but let's move to the next slide, next and final slide. First, how exactly are share options taxed if the tax exemption rules cannot be applied? The taxable value, to recall, which is the difference between the fair market value of the shares underlying the option and the exercise price, is subject to payroll taxes in Latvia and Lithuania. And in Estonia, it is treated as a fringe benefit from which corporate income tax and social tax are payable. In Estonia, the fringe benefits are not personalized. One aspect to note also about Lithuania is that social security contributions do not apply if the benefit, meaning shares, are issued by a company which is not a direct employer of the employee, for example, a foreign parent company. Therefore, the employee itself must calculate and pay personal tax in such case. And lastly, a few comments about exercise price. From tax point of view, it is up to the issuer company to decide what will be the exercise price. The exercise price can be the latest round valuation, discounted price, or nominal value of the shares. I would not recommend not applying any price. So, for example, free of charge, because usually companies cannot issue shares to themselves. So it might make things more difficult. So at least the nominal value should be the exercise price. Then the tax laws of Estonia, Latvia, and Lithuania do not also require that the exercise price needs to be the fair value at grant. For example, this is the case, to my understanding, in the UK and US to benefit from specific tax incentives. Also, there is no valuation requirement in Estonia, Latvia, and Lithuania if the exercise price is the fair value at grant. However, in Latvia, valuation is required if the conditions for the exemption are not met, and payroll taxes should be paid upon the exercise. Also in Latvia, if the exercise is not taxed to the tax exemption, the employer must report it as a non-taxable income of the employee, and the employer should be able to determine the value of this non-taxable income. So these are the basics of the tax aspects related to Estonia, Latvia, and Lithuania. And I would now give the word to Toms, who will be leading the discussion.
Hello, everybody. Thank you, Tono. And then let's move on to our discussion part. And first, I would like to discuss such general topic as motivation during the vesting period and beyond. So generally, the logic is quite simple. So the longer you stay employed during the vesting period, the more shares you get, and you should be more motivated. But my question to Paula would be, have you seen from your international practice any tips and tricks like backloaded vesting schedules or maybe something else, how additional motivation long term could be ensured for the employees during the vesting period?
Yeah, thanks. That's quite a hot question at the moment. 95% of the companies that we come across all over the world just take on that standard, what we consider to be a US vesting model. So as Crystal explained, it's the 4 years monthly vesting with a 1-year cliff. And I think our advice to clients is generally, if that works for you, stick with it. Don't have different vesting schedules for different buckets of employees, because it's more effort to keep track of. There are going to be more questions from investors doing due diligence. But then I think we are seeing this longer path of companies towards their exit. And so a 4-year vesting schedule, at that 4-year point, it loses its retention value for the company. So we're not seeing longer vesting schedules, but we are seeing top-up grants. So companies are getting to that 4-year point, and then they're making fresh grants to the key people who they want to incentivize and retain, starting again with a 4-year vesting schedule, but without the 1-year cliff. So it just carries on monthly.
Okay, so basically, after the initial vesting period has passed, there are no other real options than to grant additional ESOP, like top-up grants with restarted vesting periods, right?
Yes, I mean, we do see, and I know Crystal mentioned the sort of KPIs, we very rarely see more performance vesting targets. I think often for a specific advisor who's been brought on to facilitate a funding round or put out feelers for an M&A deal, and they're not receiving a cash compensation, they're often granted options with that as the performance target. We do sometimes see, measuring over a period. Have there been introductions that key people have made to facilitate contracts with recurring revenue? But it's pretty difficult to track who made the introduction, who made the referral. And often employees will say, well, you tested it over this period. I was nearly there. Can we retest? Can we extend the period? So I think, and no one wants to end up in court over these arrangements. So I think if you're doing a performance vesting target, you have to be very clear on the drafting and then add a bit of flexibility so that, you can't, so you're future proofing how the events will unfold.
Right. Well, at least from my practice, I have seen a couple of cases where there is some combination of both company-wide KPIs and also sometimes very specific and individual KPIs. So let's say, for example, exercise can happen only if company's market value has reached X and an employee has achieved some specific tasks. So not to run into a situation that the employee just sits around for 3 or 4 years doing the bare minimum and then gets the shares. So I understand, it's very rare in US and the UK, right, to have these specifics. Okay, so then once we are clear with the vesting schedule, let's move on to another topic about ESOP size. So firstly about the general size, so 5%, 10%, 15%. So we often get questions from founders, where do we start? What are the best practices? And we don't have any clear answer other than saying usually it's 5 or 10%, but it's really your decision. So Paul, maybe you can comment on these topics as well.
Yes, I mean, I think 10% is a pretty uncontroversial option pool for an early stage company. But as the company grows and external investors come in at the future funding rounds, I think they are fairly, it's a very strong requirement that this is linked to a specific hiring plan. And I think we see investors saying, what are the roles you are looking to fill? Have you identified individuals? What would the market expect a grant to those individuals to be? So I think you have to be more thoughtful as you go through the Series A or Series B funding rounds. And again, to the point of a longer period to exit, we have some fairly late stage tech and life science companies who now have option pools to around 20% because they've just had to, reload. They're perhaps on their third CEO who needs another grant. So I think after that initial 10%, it's very much on the facts as to what investors will tolerate from a dilution perspective. The one thing I'd add that we see a lot in the UK is if companies are bringing on a US chairman or a US CEO, their requirements are pretty high when it comes to equity awards. So that's something for companies to be aware of. And you don't want to use all the pool on one key hire because you want to make sure that down the organization, everybody is still incentivized and retained. So if that is a requirement of a new hire, that's what they're demanding, then that's the time to go to investors to say, well, we definitely need the pool to get bigger because 5% is going to our US chairman who's come on board to, see us through to an exit or a next funding round.
Okay, thanks. And Aquila, you had something to add?
Yes, I think it's some addition to the first and this second question about the option pools. I see the struggle in the companies to determine not only the option pool, but whom to award, how many options, and to keep some some reserve for the top-ups that Paula just described, as a mechanism to retain the longer motivation. Because when the company grows, for example, this 10%, just the founders might be thinking that, okay, just I have X amount of shares, I will allocate them, and then the next round will come, the ESOP will be increased, so I'll have additional shares to motivate the future employees to do the top-ups, and those rounds do not come. And then they are in the struggle that they do not have the shares to motivate the employees for longer periods. And basically, 4 years is maximum what they get. So maybe a question to Tom, so Paula, have you come across to any, apps or good reading for the founders and the companies that are listening to this webinar on how to structure this grant, just awards of the options to employees to retain the reserves for the top-ups, but not to be too greedy, and just to have sufficient motivation, but not to spend everything at once.
Yeah, it's interesting that, there are lots of tools out there, like Carter have a tool, Thielander have a tool, some of the VCs have tools where you can plug in the size of the company, the geography, and the title of the individual, and it will come out with a grant size. But I've never seen a tool which tried to also sort of think to the next stage, that if you are running out of vesting runway, what you need to hold back for the top-up grant. So perhaps if Carter are listening, they can develop a tool to help, because that's a real conundrum for companies.
Mm-hmm. Okay, so let's say we have established the total percentage, let's say 10%, but then the next big question from the founders is who is actually getting the options, and in what proportion? So are we giving the options to all employees, just the senior employees, and should there be some difference depending on seniority level? Let's say more percent to the key employees, less percent to the less important employees. So maybe you have a comment on that one as well, Paula.
Yeah, I think that's a really interesting question, because I think it really depends. Whether you grant to everybody really depends on the size of the workforce, and is everybody adding value and able to sort of really appreciate what it's coming from getting options, and committing a time period to the company. Because if you have a very large workforce, if you have a very high turnover of employees, then the administrative burden of granting very small numbers of options across the board probably outweighs the feel-good factor that you're getting from that. I think that said, we all know that very early stage tech companies have very little money, and equity is a very useful tool to make up for the fact that they're not paying cash bonuses, that they're not getting, the suite of benefits that you would get from a more mature company. So I think, there should definitely be different ratios of awards depending on level of contribution. But whether it's everybody or just a select few, I think is very hard to make generalizations.
Mm-hmm. Yeah, well, at least in Latvia, I have seen the differentiation based also on the type of business. So let's say if it's IT business, then I would say that it tends to be that almost everybody gets the options. But if it involves some blue collar work, let's say in some manufacturing, then yeah, probably just key employees would get the options. At least that's what I've seen in Latvia. Okay, then let's move on to our next topic, which is more or less nitty-gritty details about lever events. So Crystal already gave a very good introduction. But yeah, so still the big question is do we qualify voluntary leaver as a good leaver or bad leaver? So in Latvia, we have seen very different solutions. So most of all, still voluntary leaver is treated as a bad leaver because it's kind of your decision to leave the company. But Crystal, maybe you can comment in more detail. How do you see the recent trends about this topic?
Yes, well, in my view, the trend is really towards changing the definition of bad leaver for the benefit of employees, and this includes treating more and more often voluntary leavers as good leavers, or as I already mentioned earlier, also a possibility is to create a separate voluntary leaver category. In Estonia, the market standard is strongly affected by the Startup Estonia model documents. We have a very good database, and this includes an option agreement. And the default solution in the model document currently is that a voluntary leaver is a bad leaver. However, the latest volume that was released last summer also includes an optional clause that enables to bring in a voluntary leaver as a separate category. And, you know, there is not much redrafting required for this purpose, and companies use that now more and more often.
But yeah, then the big question is how do you then differentiate? So what is the real difference between the good bad leaver? That's kind of clear, but what happens in case of the special category of voluntary leaver?
Well, the solution that we have and that is now used quite often is that, as I mentioned, the voluntary leaver falls somewhere in between. So if the good leaver usually loses the unvested shares and the bad leaver loses both unvested and vested shares, then the voluntary leaver loses unvested shares and also some portion of the vested shares. The model agreement doesn't really set a standard for this portion of the vested shares that the voluntary leaver would use, but I would imagine that in most cases, companies fill in the blank in the model documents by providing for 50%. So there is a solution.
Okay, so and then the last topic I wanted to discuss, it kind of ties back to the first question of long-term motivation also after the vesting schedule. So it's about bad leaver events after vesting. So let's say employee is already a shareholder with some percent of shares and is included in the cap table. And let's say 6 months after that event, he is terminated due to some material breach of his employment contract. So do you see that there are some special solutions like taking away a certain portion of shares for nominal value or something like that?
Well, at least I feel the market practice still is that bad leaver events and actually any leaver events are usually linked to the vesting period. And usually after the vesting period, there is no repurchase right. But of course, there are exceptions, and we've seen some companies implementing that. Quite often also, the aim is not to have former employees on the cap table, and sometimes then it doesn't really even matter what kind of a leaver the person is. The leaver can be just bought out.
Mhm. Okay, so then Aquila, over to you.
Thanks, Thomas. Yeah, I have following questions regarding the later part on the exercise of ESOP. What we see in Lithuania, the most common way is to have the possibility for the employees to exercise the options after the vesting period, meaning that they become the shareholders after 4 years time, and then the companies struggle to define and to think of how to deal with those employees being the shareholders on the cap table, having voting rights, just withdrawing the voting rights, etc., etc. Paula, what is the most common approach that you see? Do you also feel that there is a tendency to give the employees the possibility to exercise the options after the vesting period, more for the psychological reasons, that I'm already a shareholder, I own shares, but not some mystic right? Or do you see this US approach, I would say more, that the exercise may happen only if there is some cash event in the foreseeable future, that is the liquidity event or exit? What's your practice?
So my preference and what we generally see is the ability to exercise as soon as the options are vested. So if we have a 4-year vest, in theory, after 1 year, the individual can exercise 25%. I mean, in reality, option holders don't exercise unless they have to, which is because they're leaving and there's a finite period of time after they've left, or there is a change of control situation and they have to exercise, or their options will lapse. The idea of an exit-only plan, so no right of exercise until that M&A deal, I think, again, to go back to this point that there's a longer period to exit, we are seeing companies that are getting to the 10th anniversary of the option grant, and there hasn't been an exit, and those options are lapsing without an ability to exercise. So if companies are very keen on keeping a very small cap table and only having an exit-only plan, we'd always recommend that there's like a 1 month, like a 9 years, 11 months from grant that you can exercise. Because often if you're amending options and saying it was exit only, but now we're going to allow them to be exercised early, in lots of jurisdictions that blows any tax efficiency because you're making a fundamental change to the terms of the option. So it's best to have that little month so you have a bit of flexibility and you don't regret it being an exit only plan. In the UK, we've got into quite a habit of when people do exercise, whether they are current or former employees, that they sign a power of attorney and proxy. So they are a shareholder on the cap table, but you're not chasing them for a signatory on a document. You're not having to send them notices of shareholder meetings to get their vote. So I don't know whether that's something that you see in the Baltics, that power of attorney concept.
Yeah, we see that and we use that, and we also, just dealing with granting non-voting shares to the employees. But then we have struggled with how to say this economic rights, right? The right to sell, for example, and even irrevocable power of attorney in theory doesn't solve that, because it's not depriving the rights of the employee, it's himself or herself to sell, just it's not that you are with the power of attorney that you are replacing and acting in your person. So there is kind of legal debate how to structure best that you do not also deal with those employees, for example, signing the next round shareholders agreement. Because usually shareholders agreement, they contain provisions on transfer of shares, etc., which already are they are not non-economic rights, they are economic rights. And basically, and if you just put everything on the power of attorney that the company will decide both non-economic and economic rights, then the employees are furious. So what do I get? Everything will be decided for myself, and etc. So it is both legal and I would say also psychological matters that need to be dealt with. And coming back to this, you said that in UK employees are reluctant to exercise, whereas in the Baltics, I would say everyone tries to exercise, and the difference, I believe, lies in the strike price, which Crystal mentioned, because I would generalize for the Baltics that usually what we see that the strike price is the bare minimum, that is the nominal value, like €1, 10 euro cents, just never in euros. Whereas I know that in UK and especially in US, the strike price should be the fair value. And fair value means already, just if you are coming and joining the company as an employee after the Series A, then the fair value is really up. And you do not want to exercise because you need to take cash out of your pocket. Whereas in the Baltics, we usually tend to give the shares for free. I think that's the difference, right? Because in UK, you have strike price as a fair value, right?
Yeah, I mean, they're not generally that high because the UK tax authorities are fairly generous at the discounts they will apply because it's a minority, because of lack of marketability. But yes, when you get to a company that's at Series B, say, then it could be, a few euros a share, that the option exercise price. And in the US, they certainly have meaningful fair market value, which needs to be used as the exercise price to avoid penalty taxes. So yes, and I don't think that there are enough tax efficient plans in the UK that you're not looking to become a shareholder as quickly as possible to move from income tax to capital gains tax, which I think is a large driver of people wanting to exercise and become a shareholder from the earliest possible date.
Okay, understood. Yeah, great. So I think I will hand the word to Crystal to move further on.
Yes. Briefly to touch upon secondary transactions. Paula, I hope, since you're here, we are all torturing you with questions, and I hope you are also willing to comment on this one. Secondary transactions, I mean, where employees sell the shares that they have acquired when exercising the options. These have become more and more common in our region. But the market is still relatively young. There is no clear market practice for this type of transactions, and we are really wondering what are the usual terms in the UK and elsewhere in your view. I mean, do you see bigger discounts for employee shares? Is there any conversion of shares from non-voting to voting, or from common to preferred when an investor acquires shares from an employee?
Yes, so it's usually the process would be that the individual exercises their option, acquires the ordinary shares, pays tax if they've made a profit, and then sells those ordinary shares as ordinary shares to the investor. And then by virtue of, by the magic of that shareholder being an investor, those shares are converted into preference shares with similar rights to the other preference shares that investor holds. We probably see two common scenarios for secondaries. One is it's a very small number of people who participate. It might be a founder looking for a little bit of liquidity, or if some of the executive team have been there a long time, and again, there isn't an exit on the horizon, then being able to at least get some liquidity for their options. And then on the other end of the spectrum, we see really large secondaries, which are managed by external platforms, where all of the employees get to participate, and it's very structured. So it's, you can exercise 20% of your vested options, a very specific window, and everything is very automated through a platform. Whereas if it's just one or two individuals, they will sign very simple share purchase agreements with the investors, just going through the motions of selling their shares. But it's either 3 people or it's 300 people is what we're seeing.
Okay, but I suppose there could be a situation also where investor already holds several classes of shares, having different rankings in terms of liquidation preference and so on. So, you know, I would imagine there are scenarios where you need to involve actually other shareholders as well, so that, you know, the conversion is managed in a way that the liq pref is also honored later. I would imagine there's quite a bit of hassle around some of these transactions.
Yeah, I think generally the secondaries we see are very tied to a primary financing. So there's only the same class of preference share that's going to be issued in the primary is what those ordinary shares held by employees convert into. So you can't look back historically and the investors can't get better terms than they would do had they invested just in the primary at that specific moment in time.
Yeah, right. Aquila, you also wanted to comment on this?
Yeah, just a question to both of you, also to Tom's. How do you see how the employees take this fact, into consideration that the startups, the growth companies, they are not listed and there is no liquidity for the shares? Because it's the questions that we usually receive from the employees saying, okay, I get the shares, I get the options, the shares, but if there is no exit, then this theoretical monopoly money becomes nothing. So, and I know that some companies are imitating some listing, just posting the value according to the rounds, although they are not listed, there is no liquidity, but there is a bit of struggle to deal with this expectation of the employees that they see the value growing up, and there is no platform, that you can see unless you create some imitating platform. And then the struggle just to sell the options and to convince the employees that options are good, unless they see some foreseeable exit or foreseeable cash out from those options.
Well, honestly speaking, I would say that probably most of the employees are not that knowledgeable to ask the question, I suspect. But I've also heard that some companies are really, not making a promise or taking any obligation towards the employee, but they clearly have a plan to structure their next round so that there will be also some liquidity for the employees. So also plan secondary transaction in connection with the primary.
Yeah, and it really helps control the dilution because you're not generating more new shares if you do give the secondary. So it's there is some virtue for the company, although obviously, unlike a primary, they don't receive the proceeds.
And Paula, have
Yeah,
you also, sorry, have you come across also to like some platforms, companies like imitating this and, showing the employees the increase of the value of shares, just to have the feeling that it's not some, zero shares, they have value and most probably there will be some cash out. Well, what's your view on that?
Yeah, I hope they don't do that without lots and lots of health warnings about shares going up as well as down. But I think it is hard for companies when employees don't see the value in their options without a reference point of a price. But I haven't seen it become the norm that companies are putting values on shares, and unless it's specifically for a new hire, where they're trying to say, we will grant you an option with this value, and it's based on our last funding round. But yeah, lots of health warnings, I think, with valuation matrices.
Yeah, I just wanted to add that there is always this possibility to say that at some point you might be able to get some dividends as well. So your shares might not have voting rights, but still you could get dividends. So probably depends on the stage of the company. If it's very early startup, then dividends are a long time away, but still some more developed companies, it's a realistic possibility and also could be a good motivation for the employees.
Okay, good. Thanks for all the comments. And finally, before we proceed with the discussion around some tax issues, let's also touch upon options in an M&A and IPO scenario. Again, I would ask you, Paula, to comment on what you deem to be the best international practice as regards exercise, continued vesting, acceleration in different liquidity scenarios.
Yeah, I think you should treat M&A and IPO very, very differently. So I think the norm that we see in plan rules is that on an M&A deal, the individuals can exercise what is vested, and then there is a board discretion to extend that to additional vesting or a full acceleration. And I think that's really useful because there will be a discussion between the parties on the M&A deal, which will throw in factors such as, the identity of the buyer, whether they have their own plans that they want to use going forward. And so they don't want the target employees to become super rich. They want them to carry on working and become part of their plan, which is, particularly if, say, the buyer is private equity, they might have a very specific way that they want to incentivize. And I think that negotiation between the parties will also affect price. It'll obviously affect what constitutes the fully diluted share capital that the buyer is trying to acquire if more unvested options are becoming vested. We do occasionally see the double trigger that you mentioned, but again, a double trigger only works if the buyer will assume those options and their shares under those replacement options to allow them to continue for the period over which you're testing whether someone is terminated or not. And so again, if you have a private equity buyer or a buyer in another jurisdiction, they might not be keen on continuing the options and respecting the double trigger. So I think that's M&A. On an IPO, my experience of investors is they're very excited about IPOs, but they just see them as a funding round. They don't see this as the company is changing so fundamentally as to warrant an acceleration or this being treated as an exercise event for the option holders. So they want normal time vesting to just continue all the way through the IPO, so through to when the company is public. But companies also have to be aware that in the lead up to an IPO, there is an opportunity to grant top-up awards. Companies generally engage with compensation consultants who will, they'll map the company against the market they're going to list on, against sector competitors. And largely, there will be increased grants, there'll be, salary increases that go with moving to that public company route. So it's not seen as an exercise event, but it's certainly something where individuals generally increase their remuneration packages.
Okay, yeah, I believe not many IPOs in our region,
Correct.
but I mean, in terms of option terms, the approach is similar. For the M&A events, at least, we have the possibility of introducing the acceleration clauses, although not often used. But the model agreement at least is silent on the IPO, which means that the vesting would just continue and would not be affected. Thanks a lot. I believe we now have a little bit of time also to discuss tax matters. So over to you, Rokas.
Hi, good afternoon, everyone. I am Rokas Daugėla, tax partner at Cobalt Lithuanian office, and I will guide today's tax discussion. Before jumping to questions, I would like to encourage everybody from the audience to post their questions, both on legal and tax part. We have time allocated to questions from the audience, so use the opportunity. And I will start our tax discussion with one of the most popular questions in a discussion, not only ESOPs, but in general. Clients most often ask us, what's new? So what are the developments, either legislative or the position of the tax authorities with respect to taxation of ESOPs? And I would like to move from the north to south. So Tonu, can you start?
Yes, thanks. So I would say that there are no specific updates or changes to the law, but I would say that the most, in my opinion, the most relevant change in the practice from the tax authority is that last year we received the confirmation from the Estonian tax authority that they will accept and apply the specific tax rules in case there is an employer of record arrangement, meaning that if there is a foreign company who has an employee in Estonia through an employer of record, for example, this team.com, remote.com arrangement, then they accept this as a foreign company as an employer and will apply these specific rules to the employee in Estonia.
Yeah, and I can continue in respect of Latvia. So the situation and trend is very similar, but the result is different in Latvia somehow. Also in Latvia, there have been no legislative changes since 2020 when tax rules for ESOPs were really modified and improved. But now there are quite a lot various questions and answers from the tax authority. And similarly as in Estonia, one of the issues which was kind of for a long time debated was whether this tax exemption is available, option is granted to employee employed through employer of record. So unlike it is in Estonia and Latvia, tax exemption is not available. So this is something to keep in mind, at least to the extent that this employer of the record is not related company to company that issues options. So which normally is the situation. Yeah. So Rokas, your turn.
Okay, so I understand that none of the countries have made any changes to legislation, and I guess that is a good thing. but just like in Latvia and Estonia, developments, they take the form of private and public explanations issued by the tax authorities. And we've seen a trend that back in 21 and 22 and even 23, taxpayers had a lot of questions about specific situations and application of tax exemptions to ESOP programs or just granting of shares. We've seen a number of answers, some of them positive, some of them not so much. And that basically resulted in a new commentary on personal income tax that was published in, I believe, second half of 2023. It's good on one hand because all those private explanations, or a lot of those private explanations, were made public without, of course, specific names, but a lot of practical examples were introduced. And I would say that it's good to have those specific situations, and the tax authorities really got more educated on the topic of ESOPs. They are familiar with vesting schedules, cliffs, and also situations where employee who has just become a shareholder has an obligation to sell those shares because it's an exit scenario. And basically, both of those situations, or many of those situations, were confirmed by the tax authorities as compliant with the tax exemption rules. On the other hand, we saw in the commentary not a very pleasant establishment that concerns changes to the ESOP agreements. And basically, the position of the tax authorities in Lithuania is that only very specific technical changes to an ESOP agreement can be made without restarting the 3-year period for a tax exemption. And we've seen this in private rulings, and now this has been made public. So I believe that this will be the official stance of the Lithuanian tax authorities. And it is very conservative, I believe, and only changes of number of shares when the share capital must be changed for some technical reasons without changing the amount of share capital, the value of share capital, can be accepted. But a lot of changes like changing the formula, changing the grantor of the option, this was not and is not accepted by Lithuanian tax authorities as a minor change, as an objective change to the agreement, which basically means that you need to restart the 3-year period. And I would like to ask this question to Sandhya first and then Tonu. What is the situation like in Latvia and Estonia? Because I believe that in the current economic situation, there can be some changes that are necessary or are welcome by both employees and employers and also investors. So what is the situation?
Yeah, this is also a hot topic in Latvia because, of course, life goes on and there are objective needs to really make modifications to initial plan. In Latvia, the law specifically states that it is possible to modify. Then you just need to notify tax authority again within 2 months. At the same time, I would say, although it's not stated that you cannot change material things, but definitely there are kind of those core things that you cannot modify without really starting everything from the beginning. What can be changed, I think, unlike in Lithuania, it seems that Latvian tax authority is ready to accept changes to formulas which are used to calculate vested shares. But again, I would say always be careful, and it's always probably better to pre-agree this with the tax authority. Regarding issuer of the options, most probably you cannot change unless there is really kind of some sort of merger or kind of classical reorganization where on a basis of law you can say that those rights and obligations are transferred to acquiring entity. Yeah. Tonu?
Yeah, I agree with Rokas that in Estonia, so there is only very small subsection in the law which deals with the tax specifics of tax share options, but there is a quite substantial guidelines published by the Estonian Tax Authority, and once or twice a year they make slight amendments to it. But it's the same in Estonia that the Estonian Tax Authority has established like material terms of the option agreement. For example, the number of shares, the exercise price, which you can amend, but usually it means that the 3-year period for the tax exemption will start to run again. However, of course, there are some exceptions to this. For example, in case of a merger or demerger, or some other corporate events, for example, for share split, etc. But yeah, there are specific like material terms, and by amending these, the new period, the 3-year period will start to run again. So we have had many questions in recent years that the valuation of the company has decreased, and the company wants to amend the strike price, the exercise price, to lower it, but the answer is that if you do it in a simple way, that there is no merger, etc., then this will start this 3-year period again.
So in conclusion, it seems that companies should be very cautious in all of 3 countries when amending the agreements, because this may lead to unwanted tax implications.
Exactly.
Sticking to hot topics, I would like to address a question to Paula about cross-border employee situations, because it's an increasing trend for people working in the Baltic states to move abroad and work remotely. Also, for Baltic companies to hire people outside of the Baltics. And the question is, how do companies deal with cross-border situations? And do they tailor the ESOPs to match one jurisdiction and one tax exemption, or they need to go to every single jurisdiction and try to basically please everyone?
That would be good work if they tried to please everybody. So I think, and it's obviously highlighted with what you've all said, every country is different. And so when companies do engage individuals, even if they're engaging them as independent contractors or via a PEO, they do need to understand whether there are tax withholding obligations on the company, whether there are securities or tax filings that they need to be made as a sort of a baseline. In terms of tax efficiencies, then obviously companies are interested in saving tax, both for them, for their employees and from themselves. I think the 2 things to remember is generally tax efficient plans are only available if the individuals are group employees. So you would need to have, a sufficient population in a country to probably want to establish a local subsidiary and have them engage the individual, or at least see it as a country where you are going to grow your workforce. And then, if that is the scenario and you've done your cost benefit analysis, then certainly we see companies trying to explore cost efficiency, tax efficiencies. There's often an extra cost associated with a tax efficient plan. You might need a sub plan that sort of reflects the local legislation. But some of the savings can be amazing. So in the UK, we have an EMI option plan for UK group employees, which can reduce the tax rate from almost 55% down to 10%. In France, there's the BSPCE, which if options can qualify, and again, you have group employees, you avoid all employer social security costs, which we know in France can be up to 45% on the company. So I think there's a series of questions that companies need to ask themselves when they do hire outside their home country. It's the sort of the entry level compliance, and then looking at the numbers and the looking to the future. It's definitely worth them exploring tax efficient arrangements.
Paula, I understand you have experience with more than a couple of jurisdictions, and you named a couple of good ones. Can you name one jurisdiction that is particularly unfavorable when we speak of ESOPs? I think that, you know, it might be of interest to our viewers to know where they need like extra attention.
So I think the country that we always red flag is China, because private companies can't grant options to their individual employee, their local employees. They can only wait until they are public. And once they are public, there's a very involved filing and reporting regime. So if anyone has PRC nationals based in China, then we always recommend that a cash bonus arrangement is put in place. Sometimes we see plans which are structured so there is a sort of a cashless sell-all exercise on an M&A deal, but I think there is a high risk of those arrangements being found wanting and just generating probably bad press locally. So companies are far safer if they are granting to Chinese nationals to just use an option plan, use a cash plan. You can use your option plan if it's a Latvian or an Estonian or a Lithuanian or a UK person just working in China. It's just PRC nationals that are the red flag.
Okay. If you don't mind, I want to continue with another question to you. Obviously, ESOP has an word employee in it, so it has to be primarily, you know, tailored for incentivizing employees. But what about non-employees or people who are technically not employees? Do ESOP programs apply? What are, you know, tax specifics that you've seen in your experience when options are granted to, let's say, service providers or through personal companies of employees?
Yeah, so we're definitely seeing a huge trend, and you mentioned it, around PEO employees being granted options under the company's ESOP. And I think there are a couple of sort of, again, questions to ask. And the first one is eligibility. So is the plan drafted such that people who are effectively indirect rather than direct service providers can be awarded options under the plan, or do you have to amend the plan or interpret the plan? And again, every jurisdiction has its own rules on how it approaches PEO employees. So traditionally, you would have a services agreement between the company and the PEO, and the PEO would then have an employment agreement with the individual. And there would simply be an option grant agreement between the company and the PEO employee. But there are some jurisdictions we've come across, and Spain is one of them, where you do need an extra contractual link between the company and the PEO employee, so a contractor agreement, because otherwise there are adverse tax consequences. If you don't have that agreement in place, then the Spanish tax authorities tax that option as a gift at a super high rate of income tax. So you need that consultancy agreement between the company and the PEO individual, and then grant the option by virtue of that. The other thing I sort of worry about with PEOs, because they sound like too good to be true, you want to hire someone in a country and they're going to look after everything, is that they often look after everything if it's to do with cash. So if there's a salary to pay or a bonus to pay, they'll make the tax withholdings. But sometimes that services agreement doesn't cover making the tax withholdings or making the tax reporting when it comes to stock options. And either it's not covered, and this could come back and bite the company, or they want to charge extra, and POs are already quite expensive in terms of their services, but often they want to charge extra if they are going to look after the equity side of the compensation package. So I think companies should use POs, with their eyes open, beyond just being very useful to deliver cash benefits. And then you talked about independent contractors and people using personal service companies. Again, I think options are a great way to incentivize people. We talked about, are these advisors having a very specific role which needs an equity incentive rather than just cash? I think companies have to be careful for the rank and file advisor, that if that advisor is exclusively working for the company, whether that's going to actually stray into becoming an employment relationship rather than an independent contractor relationship. And we see like high risks of misclassification. And obviously that moves away from an independent contractor totally responsible for their own tax to a group employee where there might be withholding and there might be social security charges on the company. So I always recommend, if you are granting options to an independent contractor, to have a really robust tax indemnity in case there is that misclassification and it blows up in terms of who was actually responsible for the tax in connection with the options.
Thank you, Paula. We're moving towards the end of our discussion, and I would like to wrap it up with another classic question, one of top 3 of every panel discussion. What are the common mistakes that you see companies in Estonia, Latvia, and Lithuania do when granting stock options, and what are the aspects in taxation that companies are missing? And I would like Tonu to start again from north to south, I'm sorry.
Yeah. So purely from tax perspective, I would say that at some points, companies, as Paula and you already discussed, provide options to, let's say, personal service companies. For example, they have a service agreement with the company and provide the option to the management board of the service company. So there's no link between the actual company and the person. So it doesn't, in addition to creating a tax mess, it creates errors in the agreement itself as well. So in this case, we cannot speak of any tax exemption, and you have to see what are the general taxation rules in this case. And also we have had cases where we have employees, but the option is granted to their company. So again, this creates quite of a mess from tax perspective and also from legal perspective. And in these cases, you cannot apply this tax exemption rules in Estonia. And also, what I would maybe say that there in Estonia, as we noted, that there's requirement to have the signatures in digital form or notarization, but sometimes still, let's say, old school companies sign the option agreement by hand, and if it's not sent to tax authority, then there is a chance that the tax authority will not allow to use this tax exemption in Estonia. So.
Yeah, I will then continue with situation in Latvia. I think now it's not that often, but at least a few years ago it was quite often mistake that companies, local employers were not aware that grant of options must be notified to tax authority within 2 months. And as Tonu said, actually there is no way how to rectify this. So you need to cancel those options and you need to issue new ones. Now I think companies are more or less aware of this requirement, but they forget that if they make some amendments, that you need to notify those amendments as well. And therefore this can be another problem. And I think the third one is we have this requirement in the law that the option must be exercised within 6 months after termination of employment. So it is very important kind of to really do this within those 6 months to make sure you can get tax exemption. Yeah, that's that I think for Latvia.
Okay, so I will wrap up with Lithuania, and I think I have two very specific examples in mind that I've seen more than once happening. The first one is when options are granted to management board members who do not necessarily have to be employed by the company. That is a problem because in Lithuania, under Lithuanian tax exemption requirements, the person must be employed, and board membership is not equal to employment, and that is taxable. Such option will be taxable. Another one, very different from what we discussed today, and this was some unpleasant news that we received from Lithuanian tax authorities, is that when shareholders of a company are granting shares to employees of the company, transfer pricing rules do apply, and shareholders selling the shares at below market value must recognize fair market value as their income, which may result in some taxes being imposed on the shareholders. So that is not very pleasant when a shareholder wishes to do a nice gesture and incentivize the employees at his expense. He gets taxed with corporate income or even personal income tax if the shareholder is a private individual. So these are situations that we should all have in mind. And obviously, it's a very clear sign that devil is always in the details. And of course, stock options is a wonderful tool to incentivize employees and at a very preferable tax treatment, but it has to be done right, because otherwise there may be some unpleasant news from your tax authorities. And with that, I think I'm wrapping up the tax discussion, and I'm giving the mic back to Aquila.
Yeah, so maybe before concluding the event, we can take several questions and spare several minutes from the audience. We will not have time to go through all the questions, but I will ask at least a couple from the legal part, and then Rokas, I will ask yourself to ask a couple audience questions on the tax issues. So the first question, I think, is more general, that is it possible to issue ESOP for the companies that are not listed? How to determine the strike price and how to ensure the liquidity? So I think, the general answer is that, of course, you can issue the ESOP to the non-listed companies, and it's mostly done with the non-listed companies because we don't have, at least in Lithuania, startups, so those companies that are already listed. And it's a way, as Paula said, just when the company is spare of cash to motivate through the wages, to turn part of the wage to the options with the future promise that you will cash out after the sale of the shares. Then the next, so very briefly, because I think we touched upon that in the discussion that followed. A question to Paula and Crystal to share the Baltic and UK perspective. Do you see cases when the employees exercise the option, they become the shareholder, that they are imposed of certain lock-in requirements after they exercise the options, not to sell the shares for certain time, like 2, 3, 4 more years? Paula, could you be the first to comment?
Yeah, so I think in private companies in the UK, we certainly see restrictions on the ability to transfer shares. So generally they'll need like board approval, there might be preemption, so an order of people who they have to offer those shares to. So generally in a private company, it's not described as a lockup, but the transfer restrictions effectively mean that, save for specific tax planning, like moving to a family trust or moving to your partner, there isn't the ability to transfer. Where we see specific lockups is obviously in an IPO situation where the underwriters will impose generally 180 days post-IPO of a lockup of shares, which is effectively to level the market afterwards and give some stability.
Crystal, can you share the Baltic experience?
I would say it's the same here, really. When the employees exercise, they find themselves in a situation where they must comply with the share transfer restrictions in the articles and in the shareholders agreement. And usually there is no prohibition to sell, but there is a procedure for that. You need, an approval, or you need to go through the right of first refusal procedure. There can be other restrictions. So it seems to be the same as Paula commented.
Okay, thanks. Rokas, do you have any questions that are more general, not just advice on certain situations from the audience regarding on the tax part?
We have some specific questions, but I believe they are really interesting, although specific. And I will start with a question addressed to Sandhya. The question is as follows. A European company listed in Nordic Exchange is providing a stock-based compensation to an employee who works in Latvian group company. The compensation rules, I believe, of a listed entity, those rules state that the parent company should pay all the taxes in its country of operation before transferring the shares to the employee. And the question is, will the employee who works in Latvia have to pay taxes in Latvia, although the rules state that taxes have been already paid in the parent entity jurisdiction? And if this is the case, how to avoid double taxation?
Yeah, well, this is a cross-border situation, so definitely it kind of involves tax rules of two countries which need to be investigated. But in general, I think it is quite clear that this is employment-related income, and both under Latvian law and also typically under conventions, employment-related income is taxed in a country where employee performs the work. So it should be taxed here in Latvia. And since it is employment-related income, and if there is no exemption available, then normally it would be Latvian employer who is responsible for paying taxes. Therefore, I would say that it needs to be investigated whether indeed there is a mandatory obligation in such situation to pay something in this country where mother company is located, because under convention, I would say it should not be the situation. Probably some residence certificates must be provided or some other documentation. But if the tax is paid there, then one would need to investigate whether there is possibility kind of to ask a refund under tax convention. So yeah, that would be my brief comment, but of course kind of more detailed review of the situation definitely would be advisable.
I totally agree with you, because I believe that even though local rules may establish tax obligations. The double taxation convention, and I believe there should be a double tax treaty between Latvia and any European
Nordic
country. And this would give priority to tax to Latvia, which means that the jurisdiction where the parent company is organized, is operating, should not have a right to tax.
Yep.
And we also have a very specific, but also I think important question concerning Lithuania. I think I touched upon it, but the question is that if top-up options are granted to an employee after 2 years from the original granting of the initial stock option, would tax exemption be granted to the top-up options after 1 year, or there is a new 3-year period to be calculated? So unfortunately, this is a material change to the option agreement, and clearly the top-up shares would have to be granted only after the 3-year period, is lapsed. And I also would recommend not to do a top-up option, but maybe to even sign a separate option agreement, just not to contaminate the shares that were granted initially, because I don't have a definite answer, but in the worst case scenario, I see Lithuanian tax authorities considering this as a total new agreement, including the originally granted shares.
But I think, Rokas, I can add that it makes sense to sign a new agreement after this initial 2 years passed, not necessarily waiting for the 3 years, because it would be a new agreement. But for the top-ups, never do an amendment agreement, do a new one as if you are granting shares anew. That adds bureaucratic and administrative burden, because you need to administer several option agreements for one employee. But I think this is the only way out to avoid taxes on the top-ups, right, Rokas?
Yeah, and I was wondering, Paula, would you say that this is a predominant way of granting additional options, a new option agreement rather than amendment of the existing one? What's your experience?
Yeah, I mean, definitely for tax efficient reasons, we have similar rules in terms of amending a fundamental term constitutes the grant of a new option. So you would leave what is in place as it is, and then you would grant a new option with a new 4-year vesting term. I mean, generally they follow each other rather than being overlapping, but either way, you're extending that period where there's stickiness with the employee and they're retained and incentivized to carry on with the business.
Thank you, Paula. Yeah, so new option agreements are the way to go.
Yeah, so I think it was a really very good discussion. And my personal conclusion is that ESOPs are really a difficult instrument when you go into the details. And I'm afraid that the standards that we have both in Estonia, in Lithuania for the option agreements, they're not sufficient to cover all the details that we touched upon. And there are more details that we didn't have time to touch upon. So most probably the good takeaway is that be very careful structuring the ESOP and the option pools. Don't be afraid to amend them to reflect the new practices and to capture the new situations, because nothing is cut in stone. But of course, be mindful what you are changing, not to make the options to this 3-year period run anew. So I want to thank everyone for the participation. I really enjoyed the discussion myself. Hope the audience did as well. Special thanks for Paula spending time with us and sharing such good insights from the UK and other countries. It really broadens our perspectives larger than the Baltic. So Paula, thank you again. And my colleagues, thank you as well for preparing and taking time. And for those who has questions still, please dare to email us and we will answer by email, because we don't want to go beyond the promised time of 2 hours. So thank you a lot, and we will see on other webinars touching upon issues important for VC practices. So keep in touch.